Okay, so we start from chapter one. We start from chapter one, overview of criminal litigation. So I believe some of you would definitely be asking yourself, what is criminal litigation? There's this notion when it's like the first time you're in the law school, you'll be like, okay, based on your basic assumption, you'll be like, criminal litigation is criminal law, law of tort is civil, uh land law or conveyancing is property law, and then company law is corporate law. Well, I doubt if that I doubt if that is really the case, except for property law, which is more like an extension of conveyancing law. I doubt if that is true. Now, um, our area of focus now is in criminal litigation, so no need to talk about other courses. Maybe when I make any audio lecture on those courses, then we can talk about them. Now, for criminal litigation and criminal law are quite distinct. You understand? They are basically or fundamentally so diverged that I think I would like to use this as a reference point. One of my roommates, one of my guy, he came to the Nigerian Law School Lagos campus with Okonkwo and Naish criminal law, and I could remember from the beginning of our stay at the Nigerian Law School to the end, we never made reference to Okonkwo and Naish criminal law. You understand? So this is to show you how fundamentally diverged these two areas are. And then another example I will give you is the first day. I think the first day we went to class, myself, my friend, and the other person, immediately, they usually pass the mic at the Nigerian Law School. You understand? So if you're not lucky, it might be touching you almost every week. You understand? So we just got into class, and the mic was passed to one of my classmates, my friend, and they asked, "Can the National Assembly issue a warrant of arrest?" To be very honest, all throughout my years in the university, I never like I never had any idea. I never had any such idea. You understand that the National Assembly can issue a warrant of arrest. You understand? So this goes to show you how diverge criminal litigation is from criminal law. You understand? But at the same time, you don't need to worry. You understand? They actually share a symbiotic relationship. For instance, I will always say you cannot talk about criminal litigation unless you talk about criminal law. You understand? That is why I gave a description. I believe that description is fundamental. You understand? I said criminal litigation is simply criminal law in motion. You understand? For me, I think that is the most appropriate description of criminal litigation. You understand? Criminal litigation is rather, for me, is rather described than defined. You understand? Is rather described than defined, and it is rather described as criminal law in motion. For instance, when you were in the university, you will hear you will notice that, for instance, when you did criminal law, your attention and your lectures were usually based on what is stealing. You understand? What constitutes the ingredients of stealing? You understand? The defendant in that case had intention to permanently deprive the owner of the thing thereof. You understand? These are critical questions that usually arise for criminal law. But now in criminal litigation, we are no longer concerned with those questions. You understand? In criminal litigation, we are no longer concerned with those questions. Now, what we are concerned about now in criminal litigation is the practicality. You understand? What we are concerned here now is the practicality. Now, when I say the practicality, in criminal litigation, we are not concerned with what is the offense of stealing or what are the ingredients of stealing. Although, yes, you will still come across those a little bit of those things. You understand? But in criminal litigation, now we're talking about you know if, for instance, now, like, we are concerned with the defendant who committed this offense of stealing. They say, look, it is Mr. Musa. You understand? In criminal litigation now, we are no longer concerned with what Mr. Musa did. We are concerned with how to find Mr. Musa. You understand? That is where you talk about searches and arrest. You understand? So we have to look for Mr. Musa's whereabouts. We have to go to his house and execute a search, by virtue of a search warrant issued by a judge or any other officer having the power to do so. And then when we see Mr. Musa, we have to also arrest him, you understand, by virtue of a warrant of arrest. And then when we arrest Musa, that is the police officers, for instance, they will take him to station. And then when they take him to police station, Musa is not going to stay there forever. They must have to prefer a charge. You understand? The attorney general will have to prefer a charge. You understand? Probably within 2 months or 3 months, depending. You understand? They will have to prefer a charge. That is to bring him before the court. You understand? So in criminal litigation now, that charge, that charge which is going to contain the offense committed by Musa, you will know how to draft that charge. You understand? You will know how to draft that charge sheet. And then when we bring Musa to court, we usually put Musa in the dock. We'll tell Musa to stay in the dock. That is a particular place in the court which is meant for defendants. You understand? And then the registrar will usually come read the charge to Musa. I say, Musa, on so day, so day, around so time, you are alleged to have committed this offense against so person. You understand? Then Musa will either say guilty or not guilty. And then the prosecution will come to give evidence, adduce evidence, call his witnesses. The defense will also do the same thing. And then the judge will definitely might probably adjourn, and then on the next day will probably convict Musa. You understand? Convict him. And then maybe after convicting him, they will tell Musa to do one or two allocutus. And then Musa will come and beg the court, my wife is pregnant, my this or that. You understand? So I'm trying to give you a foundational knowledge of what criminal litigation is all about. You understand? And then after that, what happens? They probably pass judgment on Musa by sentencing him to probably 5 or 7 years imprisonment. And then, as usual, that's not the end. Every criminal in Nigeria usually appeals. They don't want to go to jail, even if they are manifestly culpable or guilty of the offense. You understand? And then Musa will tell his lawyer, we have to appeal. Or, he will tell his lawyer, please, I will have to appeal. I can't spend 7 years in jail. And then what will the lawyer do? The lawyer will file what they call notice of appeal. You understand? He will file a notice of appeal at that high court that convicted Musa. And then now, the Nigerian law school is telling you that you must know how to draft that notice of appeal. You, as a student at the Nigerian law school, you understand? We have drafted the charge sheet, and then now you must know how to draft the notice of appeal. Yes, because after law school, you're called to bar. You might probably be Musa's counsel tomorrow. You understand? Musa will tell you, draft a notice of appeal. You're not going to tell Musa, we didn't learn how to draft it too. They just taught it, that kind of thing. So the Nigerian law school is practical. You understand? It's very practical. So you have to draft that notice of appeal. You get, and then you draft the notice of appeal. You file it, and then whatever the court decides on appeal and so forth. You understand? So I just give you a background knowledge. I just give you a background knowledge of what criminal litigation is all about. So in criminal litigation, everything is procedural. You understand? We are not unlike university. We are not concerned with what is stealing, what are the ingredients of stealing, and then we look at one or two cases and we are done. No, here we go deeper. You understand? We go to the practice and procedures. How to bring him to court, how to draft that charge sheet, and other fundamental issues that you look upon. You understand? So that is why I describe criminal litigation as criminal law in motion. So you see, we just put in motion the offense of stealing. You understand? And then if you're with my work, you see that I try to create a kind of basic terms in criminal litigation. So you should have to familiarize yourself with some of these terms, because as long as you are doing criminal litigation, you come across these terms, once in a while. So the parties are the main actors in the criminal case. You understand? The parties are the prosecution and the defendant. They are the parties. They are the parties to the case. You understand? They are the parties. And then we have the complainant. Now, the complainant in the case is the state. You understand? The complainant is the state. You understand? The state or the Federal Republic of Nigeria, depending on the nature of the offense. You understand? I believe in your university, you were told that crime, when a person commits a crime, is an infringement against the state. It is not against the victim. You understand? In criminal litigation, the victim is called the nominal complainant. He doesn't really have any rights. You understand? He's just a nominal complainant. The main complainant is the Federal Republic of Nigeria or the state. You understand? The state or the state. Though they are the main complainant because it is their rights that you violated. And then we have the prosecution. That is the team, the legal team that is representing the complainant, which is usually the Attorney General of the state, or maybe a private prosecutor in permitted cases. And then the Attorney General oftentimes is represented by state councils. You understand? State councils. It's very hard before you see the Attorney General in court personally. He's usually represented by state councils. State councils. And then I hope you know, in some cases, depending, like for instance, if you're prosecuting in the magistrate court, the prosecution will usually be the commissioner for police. You understand? The prosecution will usually be the commissioner for police. If you're prosecuting in magistrate court, it usually be the commissioner for police, and then the defendant is the accused himself. You know, we no longer call them the accused; we call them criminal defendants. You understand? And then the victim, the nominal complainant, like we said, is a person against whom the offense was committed against. And then material witness. The witness is material where his evidence is fundamental. His evidence is very very necessary to establish a case. You understand? In criminal litigation, for instance, you'll be seeing stuff like PW1, that is prosecution witness one, or you see DW1, that is defendant witness one. You understand? Oftentimes the material witness will come to testify first. You understand? They'll come and give account of what they know of the case. And then jurisdiction. We all know what is jurisdiction. Jurisdiction is authority which the court has to hear and determine a case. If you want to know if a court has jurisdiction over a matter, you look at the law. Understand? You look at the law regarding that particular matter. You first of all look at the constitution or look at any other procedural law. Understand? We'll go further down. We'll get to see some procedural laws. Understand? Then we'll look at the parties as well. We look at the parties. We look at the subject matter of the dispute. If for instance it's an offense of rape, the state high court has jurisdiction to try the matter. And then what if it's an offense relating to drugs, drug trafficking and all that? They know that by virtue of the subject matter, the jurisdiction now vests on the federal high court. And then when we talk about substantive jurisdiction, it's just a type of jurisdiction. It has to do with the subject matter. Does the subject matter fall within the jurisdiction of the court in which the said matter is brought? Then it has the jurisdiction to hear the matter. And then we have what they call territorial jurisdiction. That is to say, if that particular court has the jurisdiction, that is to say, does it have the power within that geographical area to give that judgment? I think you can remember the case of this recent case, Wole Olanipekun against Dele Farotimi, where defamation was committed in Lagos, and then he took the defendant to Ekiti State. And then I think one of the objections the council raised was that the Ekiti State High Court, the Magistrate Court, was not seized of the jurisdiction, to hear the matter due to territorial limitations. Although we'll still get to the concept of territorial jurisdiction of the State High Court, then you see how wide the territorial jurisdiction of the State High Court can be. But that's a business for another day. But just know that where, for instance, an offense is committed in River State, such offense is started in River State and is concluded in River State. You can't go and try the defendant you can't go and try the defendant in Lagos. You understand? That's the general rule. You can't go and try the defendant in Lagos, provided the offense started in River State and ended in River State. You understand? And then charge. Charge has to do with charge, or you can just say charge sheet. You understand? It has to do with that document containing the offenses for which the person committed. And then we also have what they call information. Now, information is a type of charge. But it's usually used in high courts in the south and high courts in the federal capital and the high court of the federal capital territory, Abuja. You understand? It is a type of charge, but it's more comprehensive than a charge. It's more comprehensive than a charge in the sense that you usually see what they call preamble. You understand? It contains a statement of offense alongside the particulars, providing details of the allegations. So an information is just a type of charge, you understand? But just that is more comprehensive than a charge. For instance, in exam, nobody will tell you draft the information. They will usually say draft the charge, and then it's from the scenario that you will know that you're supposed to draft an information and not a normal charge, you understand? And then arraignment, like I said before, this is the process of bringing the accused person to court, reading the charge to him, for him to plead guilty or not guilty. And then we have what they call opening address. Now, this is more like initial statement made by either the prosecution or defense before the prosecution begins. For instance, the attorney general, or if he's represented by state counsel, before he begins his case, he usually do what they call opening address. He will address the court. When I say open address, I don't mean he will greet the courts. No, he will make what they call opening address. He has to provide the list of documents he has to support his case, list of witnesses he's going to call, the fact of the case, evidence he's going to adduce, just like a summary of what he wants to do. in order to see that the court convicts the defendant. And then when the defense counsel also comes after the prosecution has finished, the defense counsel will also do his own opening address. List of documents is going to tender, evidence is going to adduce, and all that. Trial. Trial has to do with the judicial process. Like it's the totality of the whole process in court. Where parties exchange their documents, arguments are made. The totality of those things is what they call trial. You understand? And then motion. Now this is very very important. Motion. In fact, it's even more important in civil litigation. When we get to civil litigation, you find out that motion is very important. See, anything you're doing in court, anything you're doing at the Nigerian law school, it starts with motion and ends with emotion. Anything you're doing starts with emotion. For instance, you want the court to do something for you in a particular case. Maybe you were asking the court. Okay, maybe you brought an accused person or defendant that he committed the offense of stealing, and then you want to amend the charge. Maybe you want to include more counts. You later find out that he didn't just commit the offense of stealing, but he also committed the offense of rape. You won't just go to court and tell the court, my lord, we found out he also committed the offense of rape, and we want to include it in the charge sheet. No, you don't do that. You understand? You don't do that. You will have to go by way of motion. You understand? Motion is the language of the court. Motion is the language of the court. You understand? Motion is the language. So just like you go to shops and buy your groceries and all those things with your money, in court everything is done by way of motion. That is the language of the court. You understand? Emotion is a formal application brought to the court requesting the court to make specific orders. You understand? It could be order of amendment of the charge, for the court to allow you to grant you leave. For the court to grant you leave. Leave is a permission. For the court to grant you leave to amend your charge or to do whatever anything you want to do, anything you want to ask of the court, it is by way of motion. And then motion can be ex parte or on notice. When it's ex parte, it simply means that the opposing party is not aware. You understand? The opposing party is not aware. So if, for instance, the defense counsel is bringing an ex parte motion, it implies that the prosecution counsel is not even aware. It is usually used for urgent matters. You understand? And we are not putting the other party on notice, will not in any way be prejudicial to him. Like it's not going to have any negative consequences on the other party. And then we have on notice. Now, in the case of a notice, it is served on the other party. Yes, and the other party has notice of it. The other party gets the copy, say, oh, okay, this person is moving a motion. He wants to bring more charges, against me or against my client. So, oh, there's problem. Oh, so I need to get more defense and all that. And then emotion does not just go like that. Emotion doesn't go like that. Emotion goes with two things. One thing supports emotion and the other accompanies the emotion. So when you file your motion, whether on notice or ex parte, you usually you will usually support it with what they call an affidavit. Now, an affidavit is simply a document containing environments, that is statements. It contains statements. You understand? You will first of all introduce the person making the statements in the affidavit. One person will usually make the statement, and in this case now, you could be the material witness. If for instance now, okay, let me give you a scenario. Maybe uh, you are bringing the person to court for the offense of stealing, and then you have a material witness for that one, and then later you find out that the person also committed the offense of rape. You understand? The person also committed the offense of rape, and then you see a material witness for that offense of rape who say, "Oh, I was there. I saw everything. I was there. That kind of thing. I saw everything and I was there." You see a material witness on that. Now, if you want to amend the charge, that material witness will have to depose to the affidavit. If you want to bring a new count, of rape, it is the second material witness that you're going to depose to the affidavit. The first paragraph, he usually introduce himself. I so person, adult male Christian. You talk about you say his occupation, say what he does and where he lives, and then that he makes the following statement as follows. And then you start saying that on so and so day I saw the defendant, blah blah. He will just make one or two statements, and You will see the sample draft of affidavit. You must know how to draft affidavit. It's not hard. You understand? You must know how to draft affidavit. And then we have what they call written address. Now, a written address will also accompany the motion. A written address will also accompany the motion. It's important to have a written address because written address contains legal argument. You understand? Now, it's not just about amending your charge sheet, for instance, and including the offense of rape against the defendant. You have to also prove to the court that it is possible, within the bounds of law, like it is permitted by law for you to amend your charge. You understand? That is what you argue in your written address. Written address is for legal arguments to say that, oh, what you want the court to do for you and what you are bringing before the court is legally permissible. There's this maxim, lex non cogit ad impossibilia. The law cannot compare the doing of impossibilities. You understand? So you will have to tell the court that, or you give reasons. You understand? You give reasons or grounds why the court should actually grant your motion. You give reasons predicated on law, legal reasons and grounds why the court should allow your motion. And then objection. You know what is objection? You can raise objection. The court does not have jurisdiction to try the matter and all that. You raise objection. I hope you don't. For instance, if you're raising objection against jurisdiction of the courts, you don't go to the court and say objection, my lord. It's usually you have to fight something. Effect. They will know what is adjournment. And then the final address is the opposite of the opening address. The final address is done after the parties have adduced their evidence. Prosecution has called his evidence, has concluded his case, and the defense has called his evidence and concluded his case as well. And then you now have the final address. Now they will not have to address the court. The final address is where you showcase your advocacy. It's where you showcase your advocacy. You then argue and blow all your grammar as a lawyer. The essence of a final address is to persuade the court to give judgment in your favor. And then we have judgment. Now, judgment is the final decision of the court, which determines the rights of the parties. And it will usually end either in a conviction, acquittal, or discharge. We should know the meaning of acquittal or discharge. When a person is acquitted, it means that he can't be brought back to court again. But in the case of discharge, it's just a mere discharge. Okay, go first. The evidence against you is not strong. Just go first. Whenever we find a real evidence, we'll bring up your matter. Yes, so that's actually the difference. And then allocutus. We all know what is allocutus. The defendant will come and beg. My wife is pregnant. My father died 2 days ago. My mother is in hospital. My lord, I cannot serve the maximum punishment. I'm a first-time offender. Blah blah blah. That's what they do in allocutus. He's the defendant himself. That is a convict. We refer to him as a convict because he has already been convicted. He's no longer a defendant. He has been convicted. So he's a convict himself who is going to make an allocutus, not his lawyer. And then a warrant. Anything the court wants to order. A warrant is a court order authorizing either the police or any law enforcement to either probably search the premises of a person, that is search warrant, or to arrest a person, that is a warrant of arrest. And then appeal. Like I said, every criminal in Nigeria don't want to die, even those who murdered people, even if the evidence is clear, they want to appeal as though they will bring in new evidence on appeal. They will definitely want to appeal. So, when they appeal, they will go to the higher courts and try to attack the judgment of the lower court, or try to attack the reasoning, so that probably the court of appeal can see reasons to acquit them. And then the appellant. So when a person appeals now, he's now called the appellant. If for instance now you're drafting your notice of appeal, he will usually be called defendant stroke appellant. That is how it's done. Understand? And then the other person would then be complainant respondent, vice versa. That's how it's done. So now, when it comes to criminal litigation in Nigeria, there are four sources. We have the primary enactment, we have the secondary enactment, we have application of English practice and procedure in criminal matters, and then we have judicial interpretation of statutes. Now, when we talk about primary enactment, the primary enactment are the major laws, they are the major laws or the major legislations regulating criminal litigation in Nigeria. Now, the truth is that in practice, like what you have in real life in Nigeria, every state has their own procedural law. You understand? For instance, if you go to Abia State, you might see something like Administration of Criminal Justice Law of Abia State. If you go to River State, you might see Administration of Criminal Justice Law of River State, and so on and so forth. You understand? But for the purpose of the Nigerian law school, we have only three jurisdictions in Nigeria. For the purpose of the Nigerian law school and for the purpose of exams, we have only three jurisdictions. That is the Administration of Criminal Justice Act, which is applicable in Abuja, that is the Federal Capital Territory. And then we have the Administration of Criminal Justice Law of Kano State, which is applicable in Kano and all the northern states. Now, this is very important. You have to listen carefully, you understand? So, the Administration of Criminal Justice Law of Kano State is applicable in Kano and all northern states, apart from the FCT. FCT has its own law called the ACJA, that is Administration of Criminal Justice Act. ACJA, that's the short way to call it, ACJA. And then we have the Administration of Criminal Justice Law of Lagos State, now which is applicable not just in Lagos State but in all southern states. You understand? So you might see a scenario in your exam where they say the police officers did something in Bayelsa, or the criminal is in Bayelsa and they arrested him in Bayelsa. So just know that the appropriate law to cite is Administration of Criminal Justice Law of Lagos State, and it also has this amendment, 2021 amendment to that law. You understand? So this distinction is very very important, very very important. So anywhere you see the scenario, know the appropriate law to apply. This is for the purpose of the Nigerian law school and the examination. ACJL Kano applies to Kano and all northern states. ACJL Lagos applies to Lagos and all southern states. And then Administration of Criminal Justice Act, that's ACJA 2015, applies only in the FCT. It's very, very important. I know some of you might be wondering, are we going to memorize these three places? Don't worry, when we get to that, we'll know how we can do that. So, the ACJA applies to offenses created pursuant to the Act of the National Assembly. You understand? So it's a federal legislation. It applies to acts created by, it applies to offenses created under Acts of National Assembly. And the federal high courts apply the ACJA, National Industrial Courts apply the ACJA, that's the NIC. And then state high court, yes, state high court applies the ACJA in certain circumstances. You have to take note of that. And those circumstances are simply when they are trying federal offenses. You understand? So when state high courts are trying federal offenses, they will have to apply the ACJA. You understand? Because the ACJA is a federal legislation. If a state high court is trying a federal offense, the ACJA will apply. You understand? You might ask yourself, when will a state high court be trying a federal offense? Now, we'll still get to that later on. You understand? But it is possible that, for instance, a person in a River State, for instance, commits an offense, which is a federal offense, maybe hard drug, trafficking in hard drugs, and then the Attorney General of River State can decide to get the fiat. Fiat is like authority of the Attorney General of the Federation to prosecute that person, and then they will prosecute the person in state high court. You understand? That is one example. Another example is that there are some laws made by the National Assembly. There is some acts made by the National Assembly which allows state high courts to try offenses created under those laws. Some acts are like that, you understand? For instance, under the EFCC Act, the EFCC Act is a federal legislation, but it allows state high courts to try offenses under them. So the EFCC can choose, for instance, High Court of Lagos State, or they can choose the Federal High Court in Lagos State. Any of those want to try their cases. You get to try their cases. Then the Code of Conduct Tribunal also applies the ACJA. And then the Administration of Criminal Justice Law of Lagos State, like I said, it applies in Lagos and then presumed applicable to all southern states. The Administration of Criminal Justice Law Kano applies to Kano and all northern state, like I said before. And then we have secondary enactments. Now, the secondary enactments are like every other legislation that is relevant to criminal litigation that you can think about, like the Constitution. Under the Constitution, you have your fundamental right, very important, Chapter IV. You have to know all the rights there, because, for instance, if they're arresting a person is in the police station, whatever, the person has a right to counsel, he has a right not to be compelled to give evidence, he has a right to be informed why he's being arrested. All those things are contained in the Constitution. And then the Supreme Court Act as well, Supreme Court rules, Federal High Court Act, all these laws here, they are all necessary. Police Act, for instance, very important, guides the police officers on how they can operate, even EFCC Act, Anti-Torture Act, Nigerian Correctional Services Act, and all. They are inexhaustive. They're inexhaustive. And then we have the application of English procedure and practice in criminal matters where there is a lacuna. Now, there was a practice in Nigeria, and the practice was that if, for instance, the courts in Nigeria were actually they were actually dealing with a case in court, a criminal matter in court, and then an issue comes up and there is no law, there is no law in Nigeria that relates to that issue. Now they were enjoined, like they were encouraged to implement or to borrow from their English counterparts. They could borrow from the English principles and law to resolve that issue. For instance, in a custom and exercise board against Hassan, they said the question arose whether a person could change his plea anytime prior to sentencing. There was no provision in relation to that in our law, and the court applied the English law. You understand? And the court applied. For instance, a person has said not guilty, and then can he later change it to say guilty? Or a person has said guilty, and then he wants to later say not guilty. So can he later change it? There was no law like that in Nigeria, and the court applied the English law. You understand? And then I don't know, some of you might like see also immediately against EOP. This case now, custom and excise board against Hassan. The facts we are just written here just for emphasis. You understand? Once in a while in the notes, some facts are written out just for the sake of emphasis. But at the Nigerian law school, you don't state the fact of the case. You understand? You must have to learn that. I mean, that is one thing I altered my brain to learn. At first, I didn't like it because I already was okay with the university pattern where you memorize the case and the fact. But in the Nigerian law school, we don't memorize the fact. You just once you state the principle of law, you just give an authority. See the case of custom and excise board against Hassan. You know, you don't. Yeah, in fact, you're not even supposed to be like in the case of the court held. No, just say what the court held first, and then say see the case of so and so. Yes, and that is how they do it. So the Nigerian law school is like is is tripartite in nature in terms of answering your question. One, foundation, and then second one is the principle of law, and then third one is authority. When I mean foundation, I'm talking about like when you come with a general rule first, you say generally or as a rule, the law is that that kind of thing. And then you give the foundation that is going directly. What did the court say in a particular case, or what is the law, and then your authority, either a section or a case law, as the case may be. You understand? So, like I was saying, the Nigerian courts were actually encouraged to apply English laws where there was a lacuna, that is, where the law was silent, for instance, in Nigeria. But that is no longer the position of the law. You understand? That position of law has changed. Now, currently, they say our courts are enjoined to adopt any procedure at all that ensures substantial justice between the parties. Our courts now, where there's a lacuna in any matter which is not covered by our procedural law, you understand, they are enjoined to adopt in they can just use any procedure at all that will do substantial justice in the case. You understand? It doesn't need to be the English practice and procedure. They can adopt any procedure at all. They can adopt any procedure at all. But it's relevant to know that in the north, in the north, you understand, in the north, they say any such procedure that ensures substantial justice shall not in any instance include the practice and procedure of England. You understand? So in the north, they completely ruled out the practice and procedure of England. You understand? So if you look at the position of law in Lagos and FCT, that is in the FCT and in the South for the purpose of your exams. You understand? When I say in Lagos, I want you to think that I'm saying the South as a whole. You understand? And then when I say in Kano, I'm saying the North as a whole. You understand? So in Lagos and in Agja, they say the court could adopt any procedure at all, that is going to do substantial justice. So even if it's English practice and procedure, they could still adopt, you understand? But they are not bound to adopt it, you get. But then in the north, they can adopt any procedure at all to do justice to a case where there's a lacuna, but such procedure they are going to adopt does not include the practice and procedure of England. And then another source of criminal litigation is judicial interpretation, that is case laws, you understand, case laws. There's this thing, I think I heard it from I don't think I'm not in a, I didn't like I was in Lagos campus, but I have a lot of friends in Abuja, and they're always saying Olowo Noni, Olowo Noni. I believe he's a very competent lecturer, though I wasn't privileged to have been taught by him. You understand? I think he said something. He said He said judicial cases, like decided cases, are more like breaths. The court breathes, breathes life into the law by virtue of judicial cases. In the course of this criminal litigation, like the whole course, you understand that there are a lot of cases where the court has given interpretations, interpretations that has altered the literal nature of a particular statute. I shouldn't be explaining this stuff. You already know the essence of the golden rule. You understand the golden rule, and what's that school of law again? The reality school is what the court say that is the law. That is the law. That is the law. And nothing more pretentious than that. So we talk about the settings of a criminal court. I shouldn't stress this because when you go for externship, you see all these things, and the bench. The bench is where the judge stays, or where it is a jury, where the judges stay. And then the bar is where you find the lawyers. When you get to court, or any of you who has gone to court before, these are very practical, physical things. Understand? Practical, physical things. And then we have we have the gallery. We have the gallery. That is where people, spectators, audience stay. And then we have the dock. That is where the defendants will usually stay. And then we have the witness box, where the witnesses will go and testify, PW1, DW1, whatever. And then now this is very important as well for the purpose of the MCQ, sittings of the court. Now the court sits year round from Monday to Friday during the time of 9 a.m. to 4 p.m. Very important. You have to take note of that. And then there's something called non-juridical days. Non-juridical days include Sundays and public holidays, Easter week, and December 24th to January 2. When we say non-juridical days, it simply means that the court does not ordinarily sit these days. You understand? The courts are not supposed to sit. And if the court sits and gives any judgment or whatever ruling or trial, the law is that such ruling, trial, or judgment is a nullity. You understand? It goes to nothing. It's void. You understand? Because the court is not supposed to sit during that time. That was the decision of the court in Balogun against Odumoso. You understand? So just like I told you, once you just give you give the principle of law and then you give authority and go your way. You understand? So that is the general rule. You understand? No superior court sits on non-juridical days. Such sittings are a nullity. See Balogun against Odumoso. However, if the parties consent, then such sitting is going to be valid. You understand? Or where it is authorized by a statutory provision by law, then it is going to be valid. Now, it is possible that probably maybe the court wanted to round up everything today because of the public holiday tomorrow, and then due to time, the court could not. And then the parties agree, say, my lord, okay, why don't we convene tomorrow so we can just wrap this thing up? This case has taken so long already. Prosecution and defendants are in accord that the court should reconvene tomorrow. And the court is like, do you people agree to that? And they all agree. It's fine. Then the court can sit the next day, which is a public holiday, and give his decision. And it's going to be valid because the parties agreed. So now, if you look at this, the way this notice is arranged here, it's just like how you answer your exam question. Understand? And then I hope in answering your exam question, you don't write too much talk. This is not the university where we build foundation and build foundation. In the university, we write to impress our lecturers. Those who want to make A's. There's usually this prevailing custom that you're not just writing, but you're writing to impress your lecturers. Understand? So you try to build your foundation so much and write as much as they don't do that here. We don't do that here. So now imagine this was an exam scenario. Now what you can just be like generally court sits year round Monday to Friday from 9 a.m. to 4 p.m. Understand? And the non-juridical days include Sundays and public holidays, Easter week, etc. See section 15 sub 5 Interpretation Act. And so that is that. The first thing I made now is the general rule. You understand? It's more like, or like call it, okay, or let me just say it's more like the general rule or one of the general rule, and then you go on to the next statement, and you be like, no superior court sits on non-juridical days. Such sittings are a nullity. See Balogun against Odumoso, and then you come to the exception. However, if the parties consent, it is valid. See also Sami against COP, or we authorized by statute, it is also valid. See section 40 Magistrate Court Law, Lagos State, and you're done. You understand? You don't need any explanation. You understand? You don't need any long talk. You don't need any long talk. At the Nigerian Law School, we don't do jurisprudence. What we do is practice and procedure. they will ask you to comment on the propriety of the arrest. Maybe the police officers did not follow the proper procedure to arrest the person. You don't need to start saying, firstly, arrest can be defined as. No, you don't. The examiners already know the meaning of arrest. Now, just check from the scenario if just check from the scenario if the procedure of the arrest, complied with. Because if you look at all those procedural laws, ACJL, ACJA, they state how arrest should be done, how arrest should not be done. So just look at this scenario and state whether or not it conforms with the standard procedure for arrest. And if it does not conform, you state it does not conform. If it does conform, you state and justify your answer briefly, and then give an authority, a case law preferably, and go your way. You have your marks. No need to start saying, firstly, arrest can be defined at the court in this defined arrest. No, no, you don't do that here. You don't do that. During, for instance, when you get to the Nigerian law school, during your tax, if you're in Lagos campus, during your tax, the first month of lectures are usually correction, correction, correction. It's normal. It's normal. Don't feel bad when they correct you. Correction, correction. Because most times, some students, when they are answering their tax, they will start generally according to Professor This, according to, we don't need those things. They don't do them here. Yes, I just go straight to the point. So, like we were saying, if they sit on those days, it is a nullity. But if the parties consent, then such sitting is going to be valid. And then also where it is authorized by statute, that is where there's a statute that says, okay, on exceptional instances or on so occasion, the court can sit on public holiday and do one or two things, and it's going to be valid. For instance, if you look at Section 40, subsection 2 of the Magistrate Court Law of Lagos State, it says that during annual vacations, high courts and superior courts suspend sittings, yes, but vacation judges handle urgent matters, you understand? And the magistrates are available for bail, remand, and non-custodial cases, you understand? So magistrate courts and the magistrate there will be available for bail, you understand? So they can hear motions for bail and for remand orders and non-custodial cases, and then make necessary rulings and orders, and it's going to be valid even if it's a public holiday or even if it is a Sunday. You understand? It's going to still be valid. It's going to still be valid. So on the next lecture we'll talk about someone's arrest and searches. So I hope you understood this lecture, and you also liked it. So please, I want you to do something. For every lecture delivered, any question you have, you can just put it on the comment section. You understand? You can put it in the comment section. And then most importantly, I want you to understand something. Now, at the Nigerian law school, there will definitely be variation. You understand? Everything I'm saying, everything I'm explaining, everything I'm teaching is based on my knowledge in Lagos campus. You understand? We just wrote our exam recently, so everything is still fresh. You understand? So you don't have to worry. I won't say I won't say rubbish. Anyway, I don't know, I'll tell you, just listen in class. You understand? So there will definitely be variations, especially although criminal litigation is straightforward. You will see variations a lot in, let me say, corporate law procedures. You see variations in civil litigation and property drafts. You understand? So even if you follow everything in my notes, property law, civil litigation, corporate, if you follow everything, you understand, it is assumed they are writing legal standard. If they see your script, they will mark it. You understand? Those days we're in school, you hear things like, oh, in Kano campus, they said date your power of attorney. In Lagos, they say don't date your D's. In Abuja, they didn't even say anything. So those things are just variations. When the system is Lagos campus does not mark Lagos script. It's not university. You understand? Kano campus does not mark Kano script. Everybody marks everybody's script. You understand? So they will usually come together before the what they call it before the marking. You understand? They will come together and agree on those variations. I taught my student like this. I taught my student like this, and then they will reach a compromise. So when they see your script and you are probably dating your power of attorney, they will know you came from Kano campus. If you are not dating it, they will know you came from other campuses. You understand? For instance, I think there's this argument, one guy and one guy from two different campuses. That one was like saying your property law when it has to do with what they call it, testimonium. That one said in witness of which the parties. That one said no, in witness we are of which the parties. In Lagos we didn't add we are of, but in Abuja they added we are of. So those things should not take 5 minutes or 10 minutes of your argument. Those variations should not take 10 of, because at the end of the whole day, both of you are correct. You understand? But the only problem is when those things that they agreed upon, in Kano they taught this way, in all campuses they taught consistently the same thing, and then you are writing another thing. That is when you have a problem. You understand? That is when you have a problem. That is when you have a problem. You understand? And then you have to also know what works for you in the campus. You have to also know what works for you in the campus. You have a lot of stress. The Nigerian law school is very stressful, so you have to know what works for you. You have to know if you will be attending all the classes. I'm not saying you should be on serious, but although sometimes more you don't even like you feel like covering. Although it's not now. For now, you people are newbies. You're just coming, so you don't have to say, "Oh, I want to skip class." No, you have to attend all your classes for now. It is after extension during that time exam is coming. Is more appropriate during that time to miss one or two lectures, so you have time for yourself. You understand? So you have time for yourself. You know. So just know what works for you. Know what works for you, and follow it. Don't do something because your roommate is doing it. Don't read every day, every morning, night, evening because your roommate is reading. No, know what works for you. You understand? And then take all your courses serious. You understand? Take your corporate law serious. Take all the courses serious. Don't be a victim of professional ethics. It's easy. It's easy. It's not easy. Professional ethics is very bulky. You understand? Although when you check the past question, they're asking you law office equipment and all. Yeah, like this course is easy. I won't read it until exam. No, it's very large. It's not easy. Professional ethics is as bulky as corporate law and civil. You understand? So take all your courses serious, and then whatever your lecturer says in class is paramount. You understand? If I say something here and it's conflicting with what your lecturer says, you understand? I'm just saying, for instance, if maybe you're in Lagos campus and then what I'm saying here is maybe one of the things I said is conflicting with what one of the lecturers said, what your lecturer says is paramount for you. You understand? What your lecturer says first. As you're in class, you're listening, you're taking down your notes. You understand? And then I want you to understand that in Nigerian law school, there is no sufficient specific book. Like they don't have any, although I don't know whether they were saying something about changing it. They were saying something about changing it. I just wonder why they behave like that. Although they usually give handbook, but the handbook is just a summary, like it's too summarized. Although in some places it's very powerful and good, especially in criminal litigation, handbook is good. You understand? In some places it is good. In some places it is just overly summarized. Nigerian law school does not have any specific textbook like we have in the university. If you have I.O. Smith, you have everything. You understand? For land law, it's not like this. It's not like that in the Nigerian law school. You understand? So I would think, I believe you need three things. The handbook already they will give it to you for free. You understand? So you need a good textbook. You need a good textbook. In criminal litigation, more Agaba writes too much. Actually, he talks a lot and he writes too much. Although he's still good in a way, Agaba or Afolayan or whatever, anyone you want to get for criminal litigation, I can't recommend any textbook because they over talk. You understand? So you need a good textbook. For instance, okay, let's imagine this is civil litigation. You need something like Bobai. You understand? You need something like Bobai. You need to have a Bobai textbook. Civil litigation by Bobai and Dewan. You need that in the civil litigation, and then you need to come to class and listen to what your lecturer say and take down. Oftentimes, just like exactly that's also another point I get confused about. I wonder why they don't give slides. The lecturers are very stingy with their slides. I wonder what's the idea behind that. They're very stingy with their slide. They won't give slide, but if they give you, it's fine. When Dr. Mrs. S.T. James was in my campus, Lagos campus, she's exceptional, absolutely beautiful woman. She's exceptional. She gives out her slides, motivates students. She's not just a teacher or lecturer. She's a mother. You understand? She's absolutely remarkable. You understand? She gives her slides, gives out everything. But other lecturers will not give you. So if for instance you come across a slide, although you will see a lot of slides from older years, like from 2021, 2022, 2020, but you have to be careful. Check if the laws have changed and if it's still rhyming, especially on corporate law. Check for the procedures if it's still rhyming with what you've been taught. Understand? So you have your slide, you have your textbook, you have what your lecturer is saying, and then you have a good you also have a good digest. I prefer to call them digest, not PDF. You understand? They also have a good digest like Badmus, essay Badmus is good. Conde Smith as well. But one problem I had with them is that they overwrote. They wrote too much. You understand? They just wrote too much for my liking. They wrote too much. For instance, if you go to Conde Smith, too many drafts, even draft that nobody will even ask you in exam. You understand? Why learn how to draft full matrimonial courses when at the end of the whole day why learn how to draft full matrimonial courses draft when at the end of the whole day they will just ask you from the heading to the parties for petition for the solution of marriage. You understand? So, but they are still good. Bad moons, Conde Smiths, they're all good. Have something like that. Now, everything is a reference for you. You understand? What you get in class plus every other thing is a reference. Then find a way to put all of this into a note. You understand? Making your own note is very important. Although in the Nigerian law school is very, very crazy because from Monday you have this course, Tuesday you have this course, Wednesday, if you're in Lagos campus, terrible. You go to class 8, you come back by 3 or 4 sometimes. So sometimes you ask yourself, which time am I not going to make the note you get? So it's quite crazy, it's holly bolly and all that. But then find a way to make your own notes. You understand? So from your Condi, essay Badmus, OD Michael, whatever you're using, you understand? And your slide, your textbook, handbook, compress all of them into a note. You understand? For corporate law, develop your own acronyms or your own mnemonics. You understand? Develop them on how to memorize your procedures. You understand? In criminal litigation, you will find a lot of decided cases, a lot of authorities. Take as much as you can carry. You understand? Take as much as you can carry, and then know what works for you, and then believe in Jesus Christ and be prayerful. You understand? You will definitely succeed in the mighty name of Jesus. Amen. Thank you.